you now before we're too far gone.
Yeah, I forgot to put myself on the screen.
That's probably what it was.
Sorry, everybody. So, what I was saying was it is 51 degrees, mostly cloudy where I am. It's Friday, the 30th. So, I know y'all are all excited about New Year's coming up. I hope you're all safe where you are. I know a lot of people are still under some really, really bad weather, and I hope that you're safe and doing better than some people are. I know I'm in a better condition than they are. Some people are still having blizzards. So, anyway, let's get started with this. Um, I'm doing a disclaimer right out the gate. It's my fault you couldn't hear me earlier, so I got to do it again just for those people who like to act like we don't do a disclaimer. We do. Okay, so let's get back to Darrell. Here's Darrell coming in the court for his very first time. See, Darrell Brooks is accused of driving his SUV through last year's Waukesha Christmas parade, killing 6 people and injuring dozens more. This week, he served notice he will try to persuade a jury that he was mentally ill during the incident. But if convicted, should he go to an institution instead of prison? That's the start of this process with him. I know a lot of you know this information, but there's a lot of people, believe it or not, who don't know this information. So let's, you know, walk our way through it step by step. Darrell Brooks Jr. New to uh, Darrell Brooks Jr.'s new insanity defense will be tough for him to sell in Waukesha County, which is still recovering from the horrors that November day. Um, I'm going to give y'all a look at how the insanity pleas work in Wisconsin justice system and what Brooks' attorneys will have to prove to avoid prison. Court documents. Okay, let's cover what are his charges at first, okay? So, court documents allege Brooks beat the mother of his child just before the parade began in downtown Waukesha on November 21st. Because she had not bailed him out of jail several days earlier, he had been arrested for running her over with his SUV. So he then drove the vehicle onto the parade route, ignoring police orders to stop. According to a criminal complaint, he crashed into people head on and ran them over as they lay on the ground. He finally turned off the parade route, left his vehicle, and tried to get someone to let him into their house before the police captured him. Prosecutors have charged him with more than 80 counts, including multiple counts of reckless endangerment, 6 counts of intentional homicide. Each of the homicide counts carries a mandatory life sentence. So no potential motive has emerged so far to why he did this, although his attorneys have said the officers who arrested him noticed he smelled like marijuana and his eyes were red and glassy. His public defender, Jeremy Perry, didn't return any messages that to anybody who called to him. He's remained silent on giving notice to the public about anything, whether it's intentions or not. So, what did Brooks plea? Well, Brooks pleaded not guilty. His attorneys asked the judge to move his trial out of Waukesha County due to negative publicity, but that was refused. So he changed his plea to not guilty by mental defense or defect. Wisconsin's equivalent. That's Wisconsin's equivalent of the insanity plea. And Brooks is essentially saying he was suffering from a psychotic episode and didn't realize what he was doing was illegal or was incapable of obeying the law. Well, Darrell, that's a little hard to believe. Let's check out this too.
Sorry, I copied you into that email.
I didn't read it.
Okay. It was more just for the effect.
Okay.
Now, this is Darrell's first day in court.
Oh, looking ridiculous.
Of the entire process. He has not been in court in front of a judge ever until this point right here.
So, look, I know you're waiting for Attorney Keys, right?
Yes.
I just want to know if I don't have anyone on the Zoom.
No, as of 12:15, no one had requested Zoom.
Okay,
So when Miss Dunn arrives,
She's
Miss
here.
Dunn is here,
Okay.
still nobody. Okay, thank you.
okay. Then I can start the,
Live stream.
right, it takes a little bit. There's always lots of information I have to type in, so.
I know. So I was gonna look for it.
Before I go live and we have Attorney Keys, do you have any idea how many people will want to address the court today?
Yes, we have 3 individuals that want to provide an oral statement. 3 others have submitted statements that Jen Dunn is going to read on their behalf. And then there were written statements filed previously. I believe the court has those. Those were e-filed for 3 other individuals.
Do you have those written ones, Attorney Perry?
I saw them
Okay.
online, yeah.
So Teresa, make sure the microphone is available. And then if just folks could use the victim key when,
They will, yes, to
That'd be
refer to
great.
themselves, yes.
This is still kind of the preliminary stuff that's being done, and that is done under Judge Darrell. A lot of people don't even know about this first day. They consider the first day when he claimed about his attorney he didn't want that. But this is prior to that. As you can see, the attorneys are at the table with him and helping him with this part of the case. So, see, he is still under attorneys, and the attorneys in this part of the case is to try to ask the road to appoint an examiner of their choosing to support his plea of insanity. And that's kind of insane too, but let's get on with her.
Oh, Christie's trial got adjourned.
Christie's? It did? No, it didn't. Oh, I know. Oh. Okay.
just for people sitting in the front row, we have our cameras tight. You can see, just might be captured if you're in the front row. I just want to put that on before I go live. All right, I'm starting the live stream then.
There are a lot of females in this room. And I bring that up because he seems to have a problem with females. The only male in the room that I know of so far is one of his attorneys. And right now, the female attorney or co attorney is sitting right next to him, just like she was when he was brought for what he was, whether he was pleading this or that in the beginning. So we know she has a calm effect on him, but I really think it has more to do with the male in the room. And I'm going to discuss that a little more because I think this is kind of set up uh, whoever sets up courts uh, set up this judge with the female prosecutor and things like that because he doesn't really respect females. And so I think this setting was a bomb waiting to go off at some point. And as we've learned through his behavior, this is the calmest we have ever seen him. And, the more it goes on with him and females, he fights back. So I think that's a really strategic play by the courts and by the prosecutor to have females go after him. That is just my opinion on how it eventually turns out. But let's get back to this judge. She does way too much. I wish she would just start. She plays with paper too much and doesn't get herself ready for what she needs to. But let's go on.
We're not on yet. I have to check the settings.
I should clarify. I just have.
I do have a problem with the prosecutors. Even I guess from right now, they're always laughing and joking and not really professional type situation. And I don't even know, but we can hear them and what they're saying and what they're joking about. So someone has a mic near them. And so this type of behavior goes on throughout the court. And I personally just don't find them very professional with the amount of, laughing and kidding and all that going on. And I think it aids in what makes him go off uh, because it's unprofessional and it just, I don't know, it just doesn't seem like a prosecutor should be acting this way.
What?
He mentioned in a side note he was reviewing something a couple minutes ago.
I did my copy and paste, I thought accordingly, so we'll see. I'm going to restart the whole Zoom app and see if that helps. It's not working.
My gosh, they worry about that Zoom app better than anything. And this judge, you know, no disrespect, but this happens every time he goes to court. They just drag, something's not working. I feel like somebody should get there early and make sure it's working and everything, but they go through this every time he goes to court. Something's not working and it has to, and the prosecution just talks to her across the room like, they're buddy buddy. And guess what? Darrell is paying very close attention. He may not be saying anything to anyone,
205-213.
but
Oh,
he's
I see.
very much paying attention to the actions in the room.
Okay.
Well, she beat that keyboard up.
That's always a good sound.
I just don't know why the Zoom camera isn't as important, because she's already asked, is anyone there? And first they said 3, now they said no people are there.
Work, then I'm going to need Zach.
He knows that we're not at home.
Copied everything.
This is crazy. Let me try to scoot up a little so we can get on with this program.
Okay, Zach, that's black, but it says on my thing it's live streaming.
Oh my goodness. Come on, lady.
Victims would like to provide statements either directly or through Jen Dunn.
Okay, she's
Okay, go
talking,
ahead.
so
Thanks, Judge. On March 11th, I think that's the date we were first in front of this court. And in terms of the question about when would the parties be ready, I think that we accurately represented what we understood certainly the state meant when they said that I don't think there's any reasonable way we could try this case in November or December. But I think what the question really was is to the parties' best estimate as to when they'd be ready to try the case. And in a very short amount of hindsight, with really nothing else happening from that hearing to cause this, just except for going back after that hearing, like I said at the last hearing, reevaluating all the materials and the types of materials that still needed to be reviewed, the types of expertise we were going to need, which I tried to at least summarize in the motion to adjourn. Our best estimate in terms of when the defense would be ready to proceed and be prepared for trial resulted in us realizing that October is not realistic. And so rather than waiting much further down the road when there'd be prejudice to parties or to anything with getting too far down the road with things being sent out, things being relied on too much, tried to really promptly let everyone know of what our best estimate was in terms of when we could be prepared based on the volume. The state makes a comment in its reply that we failed to advise, or whatever their choice of words were, of a trial in January. I'm pretty sure that at that March 11th hearing, we talked about if it went into 2023, that we'd be talking about March at the earliest. It's true, I didn't list off every case that I'm involved in or every other scheduling conflict, but we have been pretty forthright with the court and parties about what we have in terms of scheduling conflicts and abilities to make this all work. Also learning at that March 11th hearing how long the court parties were anticipating that this trial might last. At that March 11th hearing, and to be candid, we agreed at that hearing that October, and we put it in our calendars as October. But we also weren't able to answer the court when we were asked how long to present a defense case. And the reason we weren't able to answer that is very similar to the reason why we realized we need a date past October. And that's because we weren't able to answer it because of where we were in our review of the case, the types of issues, fleshing out the defense, and the work that remained to be done. And so really, this is pretty early, I think, in terms of, at least early in the sense of how cases get scheduled, to be having this battle about the first date that got set and a very prompt request for an adjournment. I don't think that what we're asking is out of line in the sense of kind of the length of time a first-degree intentional homicide case might take. I also don't think that I'm out of line to suggest that this isn't the typical case involving a charge of first-degree intentional homicide in terms of the volume of materials and the number of charges, the number of witnesses that have been talked about or anticipated by the state.
So I have some questions. If this court were to grant an adjournment, how much of a delay is the defense requesting, and when would the defense then be available to try this case?
I think, like we indicated earlier, I think probably mid-March of 2023 at the earliest.
You have another case with some, sounds like a lengthy case, a bit of involvement, and that is currently scheduled for how long? And it's also scheduled for trial, is that right?
It is. It's set to begin January 9th, I think, and last for 5 weeks.
Well, this is interesting. Everybody, later on thought his attorney dumped him because he just didn't want to deal with him. But what it's looking like here, looks like he has another case that he's working on. And that might be, I hate to say a tad more important, but it seems that way. They're trying to get Darrell Brooks's court dates spread out till March of 2023. That just seems like something that's not gonna happen. Not because of anything that this guy does. It's just that I think the judge and the prosecution want to get this started and get going with Darrell because it's hot on the table. So let's see what happens.
If I were to grant an adjournment, why couldn't we look at November or December? Why couldn't we try this in 2022?
Well, I think December would start to make it impossible personally for my January obligations, honestly, if we're talking about this being set for a month. and November, adding 1 month from what it currently is, I don't think would accomplish what we need to accomplish in terms of the reason for the adjournment of going from 6 months from today's date to 7 months.
Can you shed a little more light on why 6 months from today?
I cannot imagine what case this guy has more important than this one right here. And I think that is what the judge is trying to get at. I don't know if he was appointed to represent him. Maybe just in the beginnings, he's like, he can, and now it's going on. I mean, I don't know why he thought it would be a short thing with Darrell Brooks, but it's not. And I don't think the judge is going to give him that time. I really don't believe that. That's my opinion.
Today would be insufficient in order for the defense to be prepared.
The best I can say, like, I guess any case at the early stages of a case is in terms of looking at kind of preliminarily the issues involved, the volume of discovery, the things that still need to be reviewed. We're trying to provide our best guess based on that, what we can see of the work that needs to be done. And we're trying to do that in a way that doesn't shortchange us and shortchange any of the parties, in a sense where we might wind up coming in and saying, we need 2 more weeks, right? We don't want to do that. We want, when we set a date for a trial of this length and with all the people that are going to be involved in it, to not have to get it adjourned when we get closer to it. In terms of specifics, I can't tell you right now that X expert can only get us their report by a certain date. But I do know the amount of work that we need to do prior to getting materials to an expert for that review and to figure that out, and going by sort of past experience in the agency of how long some of these things take. And I feel confident in saying that 6 months, when we start to break that down into the increments, is unrealistic.
Is that something within the agency that's problematic, and the caseload and the availability of experts to review? Or is that case specific?
I think it's case specific based on just experience within and just getting experts and the amount of time it takes to review and the amount of time if there's travel involved and those things. But if it probably goes without saying, this isn't our only case, but it's getting a lot of our attention, which it deserves. So it's really, this request is based on balancing all of those things.
I asked earlier if you had seen the response filed by the state, and in that response, they list really a timeline of events primarily related to discovery. You recall reviewing that?
Yes.
Anything about that you would specifically respond to? Is it inaccurate, or is it an accurate recitation of when and what the state has provided to the defense in terms of discovery and opportunity for review of certain things, even if that was prior to the preliminary hearing?
No, that struck me as pretty accurate. We are not suggesting that the state has delayed turning materials over to us, and we were afforded an opportunity to see selected videos prior to the preliminary hearing. That's true.
Anything else you think I should consider?
The other thing that I would add, and and we're going to hear, I think, from, it sounds like some named victims in the case in terms of their position. But the defense has been, I think, proceeding diligently in this case. It has with its filing of the motion under 97122 in terms of meeting the deadlines so far and getting back to the court and working earnestly to move this case along while not sacrificing thoroughness in it. The state references Article 1, Section 9M of the Constitution, and I would suggest that the subsections that they've quoted from of proceedings free from unreasonable delay, timely disposition of the case free from unreasonable delay. I think that what we're asking is reasonable in this case, and it's reasonable considering sub 6 of that section, which is Article 1, Section 9M may not be interpreted to supersede a defendant's federal constitutional rights. And what we are doing is trying at this early stage to avoid an issue where we're at trial and we aren't prepared to offer Mr. Brooks his thorough defense that he's entitled to. And that's it. That's the reason for this. I wish on March 11th, when asked that, I guess heading into that, I didn't realize we were going to be setting a trial date at the first hearing before this court, and that's fine. And so I tried on, just 2 weeks later, when we realized it, to, at the start of that hearing, to alert everyone of that. But it's really, it's no different than at that March 11th hearing of, if it said, what, look, like we did point out, we're still reviewing discovery. A lot is to be.
I'm sorry, this guy is just doing anything and everything possible, I think. I don't know if he's really trying to change the court date for Darrell Brooks at this time. I mean, he has pleaded insanity. That's, he has done that. And this lawyer is saying he has another case and he doesn't feel like he can do it within a certain amount of time. The prosecutors are ready and the judge is ready, just Darrell's defense is not ready. And I find that a little odd. I find more like it's not another case, or it's another case that's more important to him than this one. Or maybe he feels he can't prove that Darrell's insane as he has claimed, as his defense, that he is pleading insane. Because he had said he was suffering a psychotic episode. So he has pleaded insane or with mental defect at this time when this guy is a lawyer doing all of this, either trying to move the trial date from, he's asking for a trial delay down into March 2023. So I don't understand why he would be a lawyer for Darrell, I guess. I'm assuming he was appointed because Darrell don't have no money for a lawyer. But let's continue on. He's coming up with anything and everything he can say.
Determined in terms of figuring things out, in terms of what the defense and how long will take to present the defense case. And October of 2022 isn't realistic to accomplish all of those things.
Would I be wrong if I presume that there's been an initial review of all discovery made by your team?
Well, we've certainly reviewed what has been provided to us, but in terms of a close review, I guess it depends on what's meant and what's understood by an initial review. Yeah, there aren't piles of materials that we don't know what that is, but in terms of carefully reviewing it, we're still working through it.
I know you referenced, effective assistance of counsel. I'm certainly very mindful of that, and there's not a person in this room who does not want there to be effective assistance. Obviously, within your own agency, individuals have to be certified to handle these cases. That's at least my understanding. Obviously, two of the very senior people in your office. But when we think about sort of the flip side of the coin of effective assistance of counsel, when courts like myself address those issues, right, it's the flip side of that coin. It's ineffective assistance of counsel. And in those types of cases, right, the courts are always looking at whether there's prejudice, and not just hypothetical, speculative prejudice, but actual prejudice. So I thought about that in terms of this case, and what can you point me to or set forth for me that would say if we don't get this adjournment, we will be prejudiced in this way, whether it's the unavailability of a certain witness or foreclosing a line of defense or something along those lines. Do you have anything like that?
I can't at this stage, but I'd suggest that's not the right approach at this point. That kind of post-conviction analysis, which is what would have changed when we're talking at the front end of the case of the need to investigate. That's the sort of Monday morning quarterbacking of knowing everything that happened and then having to pinpoint the singular item that someone is saying should have been different, and saying, how did it matter in light of everything that happened? When at this stage, what I can point to are what the aspirations are of the Constitution in terms of what is effective assistance of counsel, and that includes thorough investigation, exploring all possible defenses, and being diligent in just, in doing all of those things. And so sort of providing that, appellate perspective on the case prospectively, I think is sort of an impossible thing to do right now, and not really the right standard.
And I'm not saying I'm injecting into this a standard, right? But there's still some value in looking at, because I do have to make a decision here today, and a request for continuance is a decision that is within the sound discretion of the trial court. And as you all know, it's a balancing of interests, even at this stage of the game, not looking back, right, Monday morning quarterback or retrospectively, but it's really the balancing of the interests that are at stake. And I know from your filings, and including the motion to change venue and the motion for adjournment, and knowing from personal experience with both of you that you understand very well your obligations as attorneys to thoroughly investigate, and your diligence that is needed. And I certainly don't mean, I don't want to come off as if I don't think you understand that. I do understand that you understand all of that, and that is something you take very seriously. But I also think it's a valid question as to, what specifically will this extra time at this point give you? By your own statements here today, it sounds like if I grant a continuance, the entire month of December will not be able to be devoted to this case in any way due to your preparation for a trial that begins in January, which will take up all of January and part of February, right? So it cuts out a significant amount of time that you are asking me to give you to try the case. I mean, if I look at it in that way, there's not a significant amount of extra time that's going to be provided for all of you, right, unless I'm going well past March of 2023. I don't think that's an unfair assessment of the time frame that's been laid out here for me today. That brings me to why can't this be done yet in 2022?
Well, I'd suggest that it's not only me and Attorney Keys that would be putting all the hours and only us putting the hours into this case, that we'd have, especially if we talk about consulting with experts, it's allowing enough time for those things to happen. It's enough time for staff in our office to be working on this as well. I hope that by October of this year, I'm not still waiting to personally have reviewed everything in the case. That doesn't mean that everything is.
I just know that Darrell is sitting over there taking all of this in. I kind of get at this point why Darrell would think that he'd be better off doing it himself, because his attorneys really don't sound like they want to give him the attention he deserves, his case that it deserves. Even Judge Doro is saying that, if you give, if I give you this time, you're going to be spending it on this. And so when the guy gave what he would be spending it on, then that took away the time for the other case that he is going to do. So it seems like he doesn't want to, do the work on Darrell's case. I'm sorry, but that's the idea that I'm getting from what he is saying. And that's just my opinion, but it looks like he's trying to get out of it. If he was my lawyer, I would be like, this dude don't want to defend me. He has another case that he finds more important than mine. And I kind of feel like that's what led up to Darrell wanting to represent himself. But it's kind of painful to listen to, really. But okay.
Is lined up for us to be prepared for trial in terms of the other things that might be happening, especially when I refer to consulting with experts on the case.
Lastly, from a practical standpoint, we've spent now some significant amount of time preparing these jury questionnaires to assist with the analysis and the of the change of venue motion, which I think is important. It's certainly not an idea that anyone came up with in this case. It's something that's been utilized in other cases and some very high-profile cases, even throughout this country. And so from a practical standpoint, if we're not able to do a trial until 2023, then I'm not able to send out the jury questionnaires until sometime shortly after October 1. And so that puts delaying the change of venue motion, because I think it's important to have those questionnaires returned, given the size of the county that we are in and the size of the master list. Understanding, as we talked a little bit about at the last hearing, The master list for 2022 is over 314,000. I've already had our clerk's office send out 2,500 initial jury qualification questionnaires. That's just the basic questionnaire. Of that, we've had over 1,500 already returned. So it's a significant amount of people that I would want to send this questionnaire out to. Frankly, much larger is my understanding than what we did for a case like Slender Man. And I'm not saying that those are apples to apples, right? But that's what we have by way of recent experience here in Waukesha County. And so is the defense prepared for the possibility then that that change of venue motion will not be decided in all likelihood until closer to the end of 2022? And is that reasonable or acceptable?
Yeah, I think that if the court looks at this idea of the questionnaires to help decide the change of venue motion as being essential or very, very helpful in deciding it, then that's something that that we'd be okay with.
All right, I appreciate you answering all of my questions. Let me turn to the state.
Well, thank you, Judge. And I'd like to observe at the outset, I think it's something the court's already commented on. You have a tough decision here. I understand. You need to balance many concerns and many issues. Providing Mr. Brooks with a fair trial is, of course, one of those. Providing the victims with a fair trial and a speedy disposition is another one. So we understand that this is not a slam dunk motion either way. It's going to require a lot of thought by the court. The added challenge is this scheduling that we brought to light for Mr. Perry, in that you can't adjourn it 30 days, 60 days. It's either got to be October or March at the soonest. That's a significant gap, and that's a significant gap to have to explain to the victims and their families as to why we would push the trial off for so long. Mr. Perry represents to the court that they've made a reasonable request. This is not out of line. That may be true. It's frankly too difficult to assess from the information we have before us. You've asked a lot of pointed questions looking for definite answers, and we still really don't have them. They still haven't told us, when would you like this trial? How long of an adjournment do you need? The only response is, well, March would be the soonest. Are they asking for July of 2023 or March of 2023? Because that matters, right? They say things like, well, we need to do an investigation and we need to consult with experts. Has any of that started? We don't know from the record so far. They've outlined some issues that they feel may be relevant to the defense, like the interrogation of Mr. Brooks. Well, they've had those materials since December. A special plea, the possibility of a special plea, if that's going to occur, that should have already occurred, Your Honor. That has to take into account his mental capacity at the time of the incident. So raising a special plea in October isn't going to provide too much helpful information to anybody. It's hard, in my opinion, to gauge the reasonableness of the request from the defense, because I still don't know exactly what they're asking for, and I don't know that you asked him twice, what would this additional time buy you? And all they've said is more time to review the discovery and consult with experts. But if they were to come to this court and say, we've already spoken to, for instance, a DNA expert, and they've reviewed the crime lab, what is available so far, and they know what was done so far, and they're estimating 3 to 4 months for them to complete the review, we'd have something solid, something concrete that we could explain to the victims as to why this delay is necessary. But as it sits here today, we don't know if they've even consulted with one expert yet. So that's where I think the challenge comes for the court is you have to do the right thing for a lot of different people, and they're compelling but competing interests, right? Not unusual for a judge. I get it, but we're not trying to be difficult here either, Judge. I still would indicate to this court that we believe we can have our case in chief done within 5 to 7 business days. I think an estimate of a month for a trial is too long. I really do. I think this trial would be 2 to 3 weeks, easily done within 3 weeks. So can we look at October 31st as a start date, giving them an additional 30 days? That's a possibility. I would ask the court to consider that, because otherwise to have to tell these victims, we're not going to do anything on this case for another year is really hard to swallow, right? They're not going to have any answers on what's going to happen for another year. So I know you've read the written statements. I'm going to ask those who want to make statements to come forward at this time with your permission.
Before you do that.
Yes.
I just have some follow-up. Just on the trial scheduling, I know you're very confident about putting your case in chief in.
Yes.
So when I say a month, I factor into that the fact that this court has to do preliminary instructions, which will be quite lengthy, and then at the end of the trial, significant instructions. These aren't instructions that are going to take an hour, right? They could very well take a day, 2, I don't know. I haven't certainly had to instruct a jury on over 80 counts. And so I know that that adds to it as well. And then I'm also factoring into that my best estimate, I guess, at this point of deliberations, understanding that a jury has to go through each verdict one by one. And so I don't think it's at all unreasonable to think that in total this is going to take about a month's time. You know,
I understand.
it might take less, but I'm trying to be mindful of everyone's schedules and give this case the time that it needs for all aspects of the trial. You may very well be right. It can be done closer to 3. But I did want to put that on. What about, though, this idea that the trial, if it goes into November, do you think there's any potential, I guess, for prejudice there coming up on the 1-year anniversary? I know that I haven't looked at that in any specificity. If there's any case law, I would think there would not be, but have you thought about that?
I did think about that, and that's one of the factors that I mentioned on March 11th. Yes, and not only prejudice to the defendant, but difficulty for the families, right? So yes, that is something that I think we should consider. But I think we should weigh that in the scheme of things, Your Honor, or the scope of things of, does that potential prejudice and pain outweigh the need to get the case done in a reasonable amount of time?
And what about the month of December? That'd be the last, I guess, question, at least at this point. What are your thoughts about that?
Yes, I think we're definitely prepared to do this in December, Your Honor. I think the analysis is pretty much the same as far as there's still potential for prejudice and challenges for the victims if we're talking about November and December. But I think the value in getting the case completed by the end of the year outweighs those concerns.
All right, thank you. Then I will hear from anyone who would like to make a statement. Today, I only ask that you utilize the identification from the victim identification key as you do so.
Sure, so first we're going to have...
And utilize a microphone.
Yes, this is, first there'll be a comment by victim O speaking on behalf of himself.
Thank you.
Well, here we go again with her and Darrell. I was talking about her arm on the back of the chair. At least she's not rubbing his back this time. He's very calm, but he is so reading this room reading his own lawyers, especially the guy, and I don't think he feels very confident with them, but he's also, getting a feel for the judge and also for the prosecutors. That has a lot to do. This time right here, pre-trial, his getting a feel for the prosecutor and the judge plays a big part in the trial and how he acts alone. We all know that he was guilty on all charges. We all know that. But that's not what I'm doing with Darrell Brooks. I am trying to cover his mannerisms, things we may have missed in the big trial, the way he carries himself, pre-trial, how he comes to the decisions he makes. I don't think he makes them very lightly. I think he has a reason behind them. And I think watching this right here, we're basically watching his lawyer basically trying to bail on him. But that's how I take it, because everybody else is ready. Everybody. The judge is ready. She's got her game plan of what she's got to put out. The prosecutor is ready. Sounds very confident. And his talk is so slow and so drug out. And this is why we can't get it done. Mostly, I can't get it done because I have another case that's around that time. And I had my time frame worked out to work on that case, not really this case, and I don't know how I'm going to give 100% to this case unless you give me more time. That's what it sounds like to me, which is really kind of insane, not to use that pun, but I would be concerned if I had pleaded a psychotic episode and that I was incapable of obeying the law because of that episode, and that I believe I have a mental problem. The last thing I want to face is my lawyer basically giving a reason to bail out on me by I'm tied up with another case. Let's hear these prosecutor victims.
So much. If you could stand for me, please, so I can see you. Thank you. Go ahead.
I feel that the court should not grant the motion for trial to be moved even further from the current scheduled date in October of the proposal for 2023, as victims in the city itself will continue to be affected as this case continues to be lingered on or pushed out, which is something that does not need to happen, as I believe closure is the biggest thing that the victims of this case and the case itself needs.
Thank you.
And then we have the mother for victims AA and BB.
Thank
Good
you.
afternoon. As a mother of two victims in this case, I'm seeking enforcement of the statutory and constitutional right to a speedy disposition of the case, and the right to have the victim's interests considered when deciding whether to grant a continuance. Moving the trial date to 2023 will cause additional emotional distress and prevent our family and hundreds of others from healing from this trauma. The 6 killed did not have a choice of how much time they had left on this earth. The more than 60 injured did not have a choice of how much time they had to enjoy the quality of life they may never regain. This case, however, both defense and prosecution was given ample time with an October trial date. Pushing the trial to 2023 would continue the emotional distress for the victims. Judge Darrell, please consider the victim's right in this case and do not grant a continuance. Thank you.
Thank you.
And then finally, we have the granddaughter of victim A.
I understand that the trial wishes to be pushed back, but respectfully, I disagree with the idea of adjournment and would like to voice my opinion. My grandmother was one of the ones that was struck and killed by Darrell Brooks in the Waukesha parade. I was incredibly close to her, and her life was ripped away from myself, my family, and my grandmother's friends without so much of a chance of the ability for us to even say goodbye. I think that in order for my family and the other victims' families to properly heal, the trial needs to be set in October. We need to see justice on the day the trial was originally set for. We cannot rest easy or even find a sliver of peace until that is done. Trials create indelible records upon records of the facts presented for this very case. We all already know Darrell Brooks deserves to be locked up. However, trying to bring members from another county will just provide the same results. No matter where this trial takes place, people all around the entire state, county, and even world are angry about this, and we as victims deserve the justice that we were promised. Thank you, Your Honor.
Thank you. Ms. Dunn, I believe you have some statements as well you'd like to read on behalf of them.
I do. I have some statements from victims who could not neither be here or felt they could not read it themselves. The first is from the mother of victim Z. Judge Doro, 4 months ago, our daughter's dance team came out to spread joy and holiday cheer to our community. What they didn't know was that day their lives would be forever changed. Walking along the parade route, these children, adults, grandparents had one goal: to make other people smile. And in one instant, that all changed. Lives were lost and childhoods were shattered. Families rushed to their loved ones to hold them and pray they would survive. This was a moment no one will forget. In the days, weeks, and months following this horrific event, the victims and their families have endured numerous funerals, surgeries, and continued recovery from the ongoing emotional and physical pain. The defense is asking for a continuance for this trial. By doing so, these victims will have to keep reliving this nightmare. We respectfully ask for your compassion by not delaying the prospect of the closure any longer than necessary. Although nothing will mend the emotional wounds these victims have endured, moving the trial to 2023 will only prolong the healing process. My daughter and her teammates need to move on. They need to heal. They will not be able to heal until this is behind them. Please consider the victims and their families when making your decision today. Although we cannot go back in time, we can move forward, and that's what everyone needs to do. Respectfully, the parent of victim Z.
Thank you.
This next one is from the mother of victim II, victim JJ, victim LL, and victim KK. She emphasized that she is the mother of 4 children, all struck in this incident. Good afternoon, Judge Doro. I start off by asking you to please consider the victim's rights in this case and do not grant a continuance. My children who were bluntly hit by Mr. Brooks deserve justice with a speedy disposition of the case. They should not have to see this continued trauma during the 1-year anniversary and the holidays surrounding this tragedy. Let my children celebrate the holidays instead of hiding in fear of what's next. I believe the October trial date should remain and the continuance should be avoided at all costs to assist the healing with my children. The set October date should be ample time to prepare for the resolution of this case. Thank you, Judge Doro. And the final letter is from the mother of victim HH. As a victim in this case, I am asking the court to consider the victim's interest when deciding to grant a continuance. This extremely violent event has been a horrific experience for many. By moving the trial into 2023, the victims will continue to deal with the emotional and mental strain that has come with this incident longer than what we need. Unfortunately, my child did not get the choice to prolong her quality of life. Instead, she was forced into a lifestyle of fighting for her life, multiple hospital stays, multiple ongoing surgeries, and ongoing doctor appointments. This event has caused a daily impact on her life with no sure fix with the medical issues. Her 11-year-old normalcy was taken from her too soon. I am begging for you to consider finishing this trial as soon as possible so that my family and many others can find some sort of emotional ending in this incident, especially since my family is stuck with lifelong daily reminders that feels as if they will never come to an end.
Thank you, Ms. Dunn.
Thank you.
Attorney Upper, anything else from the state?
No, Judge.
Attorney Perry, since it is your motion, I'll give you any final last thoughts or words you have at this time.
Sure. An example offered by the state is a good one, talking about how we're not sitting here today saying we've talked to a DNA expert, and they've told us this is how much time it will take to analyze the DNA. The DNA is one of the things that we're still waiting on.
I can't believe this guy is still singing the same song and dance after hearing from the victims' families. Even just that alone, to why this should be a speedy trial. He keeps the same tone, asking for the same thing, and that it was like that didn't affect him at all.
And that's part of it, right? It's the just at the start of a case doesn't mean, and then the discovery's been received, and everything is just flying along in terms of the analysis. So that's an example where it would be impossible for us to have consulted with a DNA expert to do that, and it's information that's still outstanding to us.
Any other information you believe is still outstanding?
I don't know, I guess. I don't know what I don't know in terms of the things that will be turned over to them, additional statements, things that...
Did I detect attitude because he didn't get what he wanted? Or frustrated because the judge is just not going to give it to him?
That we'll learn as this case goes on. And that's part of it with the court's earlier question about what aspect would there be prejudice from? And that's sort of the, I think it would be kind of outrageous for me to say, well, like, we don't need to investigate this, because if we investigate it, nothing will come of that, right? We can only know that by kind of turning over those stones. And I'm not suggesting turning over unreasonable ones. It's all, it's based on kind of our assessments of what is, reasonable things to pursue based on what is known. And at this stage in the case, there's still a lot of work that needs to be done by us.
Attorney Apper, as you know, the crime lab and the hygiene lab, both have backlogs, and oftentimes we do not get reports and analysis of evidence until sometimes days before trial now. So tell me what, and let me preface this, I know the parties understand this, but the public may not understand this. I obviously don't have the discovery. That is not something that comes to the court. The court has the criminal complaint, the court has the various filings, and then call it offers of proof if you will at this point regarding what's out there. So if I could have a little bit more information about what evidence has been submitted to either the crime lab, the hygiene lab, or for further testing for which there are not reports received.
DNA is the last big one, Your Honor, and I did call there this morning. I spoke to the analyst who's worked the case. He indicated to me all of the analysis is completed. He has a draft of his report. He's just waiting for a peer review to be completed. He estimated I would have the report by the end of this week or the middle of next week. And other than that, toxicology is complete. I believe trace is complete. And I don't think there was anything else at the crime
Anything
lab.
done with the vehicle?
That's the DNA. There was a mechanical inspection that's been done and turned over to the defense. That was done by State Patrol. That's all complete. Yeah.
How many items were swabbed and tested, if you can tell me, for DNA?
A lot, hundreds, but they weren't all analyzed.
In fairness, I mean, not,
Right.
sometimes
So,
we have one or two items that are sent to the crime lab for testing, and if there's hundreds, that can be fairly lengthy and will take some time to review and analyze.
Sure. So I guess I would make this observation. The examination of the vehicle itself was extremely lengthy. They spent days, if not weeks, going over the vehicle meticulously for any trace evidence, any biological specimens that could be recovered from the vehicle. So they did collect probably hundreds of samples from the vehicle, but I'm not expecting analysis on all 100 samples necessarily. As you know, Judge, the crime lab will typically select samples that are relevant and, in their opinion, most likely to be useful. And this case is a little bit unique in that we have so many eyewitnesses and video evidence as to what happened that we're not necessarily trying to fill in blanks with science. Certainly it's important. It supplements what we know, but let's just say in a typical hit and run, it may be very important to know, every amount of DNA that can be found on the vehicle, but there's other factors in this case that will be able to prove that without the science.
Thank you. I appreciate that additional information. All right, what I am going to do, I want to take some time to further digest what I've heard. I don't need a lot of time, but I want to just think about some of this added information that I just learned today. I will leave the live stream up and running, but I'll have my clerk mute our court audio. I'll take at least a half an hour to do that, and then so we'll reconvene, let's say, at 3:30 for a decision.
Wow. Now I know why everybody else skipped that one. Just saying. 20 minutes for the judge to get set up, and that was just... Anyway, so what comes next in the court? Well, Darrell, now that's not counting today. She's going to take whatever time before she tells Darrell's, attorneys that they're going to move forward. And I really believe that Darrell sat and listened to today along with us is his reason for dumping the attorney, saying he can do better himself. And I gotta admit, if that was my attorney, that's what I'd be thinking too. Anyway, let's move on with this. So what comes next for Darrell? Well, Darrell will appoint a psychologist to examine and issue findings on whether there's enough evidence to support his plea. If the psychologist finds he was competent, Brooks' lawyers and attorneys can ask the road to appoint an examiner of their choosing. If there's ultimately enough evidence to support the plea, then Darrell will conduct a jury trial and to determine whether Brooks committed the offense. If he's found guilty, she will hold another trial with the same jury to determine whether he was so mentally ill that he didn't know he was breaking the law or couldn't conform his actions to the law. If the jury makes such a finding, Brooks would avoid prison. and instead be committed to a mental institution for the duration of the sentences that accompany the criminal charges. He would be allowed to eventually petition for release, however. Don't like to hear that. So, what does the defense have to prove? Brooks' attorneys will have to show by a preponderance of the evidence that during the parade, Brooks essentially lost touch with reality. I kind of would agree with that because I can't think that a person would do that in the right mind. That said, Dr. Cohen, a New York based forensic psychiatrist who was consulted on more than 50 homicide cases, said they need to show Brooks has a history of mental illness and what happened to him on the day of the parade that caused psychotic episode. Cohen said his current mental state is irrelevant. That's a little weird. So, how difficult will it be for Brooks? Extremely difficult, according to Daniel Adams, a former Milwaukee prosecutor who handled dozens of insanity cases during his tenure, even notorious serial killer Jeffrey Dahmer, who admittedly strangling and butchering 17 men or boys men and boys over 13 years and dismembering some of his victims, failed to prove he was insane during the trial. The first hurdle for the defense will be finding a psychologist willing to declare Brooks was mentally ill. They have their reputations on the line. Prosecutors probably won't concede insanity given the high profile nature of the case. They can argue Brooks' decision to eventually turn off the parade route and try to hide shows he understood his actions were legal. Somebody who's so mentally ill they didn't know what they were doing was wrong and wouldn't have done that. Excuse me. They wouldn't have hid the car the way they did and then try to find they wouldn't have walked away like that and had people help them. So because he knew what he was doing right there, that proves that kind of proves he wasn't mentally ill. Sorry. So has any of the evidence emerged suggest Brooks has mental issues? No. Nothing has been released publicly by either the defense or the prosecution suggesting he was of sound mind or mentally ill. They just haven't talked about it, really. What if he was high on marijuana? That wouldn't support an insanity defense. Defendants can't become intoxicated voluntarily and then argue that the drug caused the break with reality unless they can show it caused an unexpected reaction. So, if there's going to be a insanity plea, how will Waukesha County jury react? The incident sparked multiple fundraisers for survivors and families of the dead. People erected a makeshift memorial, attended prayer vigils, and the city officials have hung paintings of 6 people who were killed in City Hall, and anger toward Brooks still runs hot. Juries often view insanity defenses as the weak excuse. A Waukesha County jury will almost certainly greet Brooks' arguments with deep skepticism. It's going to be hard to overcome that skepticism with a local jury. You have to you have to be you have to have a pretty severe mental disturbance to not know at all what you're doing. That's true. So, have any high-profile criminal defendants successfully argued that they were insane? Yeah, sure have. One of the most famous ones is John Hinckley Jr., who attempted to assassinate the president at that time, Ronald Reagan, in 1981. He was found not guilty by reason of insanity in a federal court, and he was released from a psychiatric care in 2016. Outrage over the finding led the passage of the Insanity Defense Reform Act of 1984, which later made it harder to win a verdict by not guilty by reasons of insanity by lowering the standards of evidence for prosecutors to prove sanity. I mean, at the end of the day, with less than a month before the start of the high profile trial, Darrell Brooks has withdrawn his insanity plea, signaling a key change in how the case will be proceeded. The decision was announced in Waukesha County Circuit Court on Friday ahead of the now postponed jury status hearing that had been previously scheduled for the afternoon. Brooks, the 40-year-old Milwaukee man accused of 6 first-degree intentional homicide and 71 other criminal counts tied to the Waukesha Christmas tragedy parade in 2021, is scheduled to stand trial beginning October 3rd. On June 20th, his lawyers indicated Brooks wanted to change his earlier plea from not guilty to a not guilty by reason of mental disease or defect, a special plea that would have forced the trial to be conducted in 2 phases. Now, those 2 phases, what are the 2 phases? Well, the first phase would have dealt with the allegations themselves as prosecutors attempted to prove Brooks was responsible for all 6 deaths and dozens of injuries that resulted when he drove his SUV through the parade route on November 21. The second phase would have focused on his mental state at the time and whether it played a factor in his actions. His decisions to again change his plea eliminated that element of a trial that would have been expected to run nearly a month. In that court on Friday, under procedural questioning from Judge Darrell, Brooks offered little explanation for that decision. He said, "I have my own reasons why." After confirming he had discussed the pros and cons of his decision with his attorney to again continue on a straight not guilty plea. As the trial approaches for Brooks, prosecutors and defense attorneys have planned to meet up Friday to further hammer out some details on how the jury will be selected and how the case will be presented. But that didn't happen. But now don't get too excited. The delay in the jury status hearing had to be rescheduled for September 19th. then that's not related to the plea charge. Instead, his attorneys indicated Brooks found it difficult to be in and remain in court due to a tooth abscess. There you go, folks. The games have begun, and we've not even started yet. Every time I do another segment on Darrell Brooks, people make a lot of comments on the girl. We are going to cover the girl when she comes into court and all the many things he has done to her. I just want to make that clear to everybody. But like I say, the games have begun and we hadn't even started yet. So this is the end of this part 4. Make sure you hit the like button and subscribe. And thank you for coming by. And you have a blessed day today and tomorrow. And thank you. Good night.